Appellate Division 4th Department. Hear ye, hear ye, hear ye. All persons having business before the court will go on here. If your attendance may show your.
Thank you. Please be seated. First case on for argument today is case 912 People versus Freeland.
Good morning, Your Honors. May it please the Court, Danielle Chamberlain here for Appellant Barbara Freeland. Within the realm of post-conviction remedies, it's not actual guilt or innocence which governs, but as stated by Justice Cardozo, it's the observance of those procedures which are implicit in the concept of ordered liberty. That's obviously a tough lesson for some to learn. It's a harsh reality.
But let's get to the main point of your argument. Your main argument is sufficiency of the evidence, right?
Correct.
You basically argue that there was insufficient evidence that she falsely listed this Cushman as a member of the household, and also insufficient evidence of her intent.
Correct.
Okay.
So when you look at the two verdicts, that there was a conviction for her inclusion of his name on an application in December of 2010.
That she signed.
Which she signed.
Admittedly.
And an acquittal of identical charges, nearly identical actions. And then there's an acquittal of the application, the charges related to the application when she included his name in spring of 2012. But that doesn't comport, the conviction and then the acquittal within that chronological order, it doesn't comport with any reading of the evidence. Nobody's testimony indicates that Eric Cushman's residency changed between December of 2010 and spring of 2012. Nobody can agree on where his residence is, but nobody thinks that it has changed.
But Cushman testified in this case. Cushman testified and Blake testified that he did not live there.
Right.
When she filed this application.
Right. And they also testified that he did not live there in spring of 2012. So my argument today is that the conviction for the earlier inclusion and then the acquittal, that's chronologically impossible. It's not reasonable. It's not rational. It doesn't make any sense. I could understand if they had been flipped and there was maybe an argument as to the date as to when he moved out, but I don't understand how she can have criminal intent for including his name in December of 2010, but then with no change from anybody indicating that there's a change between December 2010 and spring 2012, all of a sudden it's a perfectly acceptable act and she's acquitted on that end. So that just doesn't make any sense to me. And I would also argue that there was less than sufficient evidence to establish that he didn't live there in any of these instances. There's, I believe, enough evidence to create reasonable doubt as to whether or not he resided there. He got his mail there. He applied for a Social Security.
Well, his getting his mail there, it was explained by him. He said he never made a change of mail. Or a change of address.
But he did use that address when he applied on his FAFSA and when he went to the Social Security office. So you have the bedrock of how we identify ourselves in this country. That's the address that he gave. When he got a ticket in the Alfred Town Court, he gave them that address, his mother's address. He told everyone, I live with my mom. He had several inconsistencies in his testimony, and the respondent characterizes his testimony as that he had some confusion. But even if you credit his testimony completely, how does it comport? It doesn't comport with the evidence, with the acquittal and then the conviction. It just 2 and 2 does not quite equal 4 in that instance. His position is consistent for both dates. So how is it criminal intent in one instance and just not in the other? Either the prosecution met their burden or they didn't. You can't split the baby here.
I think we have that argument on the inconsistency.
Okay. So as far as the inconsistencies, I'll rest on my papers for the rest of that. And then just to remind the court, he did have belongings at the residence. He said that he ate and shared meals with his family pretty much like a regular family, and that's in the record at page 330. He was disclosed on the original SNAP application for December of 2010 as an income-generating member of the household, earning significantly more than Ms. Freeland was. And when Ms. Freeland did consider him to move out in May or June of 2012, when he came and he got his stuff and he changed his address with the post office, she notified her caseworker that he had moved out. On January 11th of 2011, when the caseworker for the SNAP application called to do the telephone interview, she said, well, so-and-so moved out and then so-and-so moved in and this is the actual address. She was being consistent with disclosing information as she perceived it to be happening. So why would she make those disclosures with an intent to defraud and then not disclose if there had been a change as far as Cushman goes? She would have just let it go. Oh, maybe we have a fourth one, you know. Now we have 4, we'll get extra. That's just not what she did. She said to her view, she was as truthful as she could have been. So I'll just, before you can get to intent, you have to establish the falsity. So if there was no false action taken, you can't then analyze the intent because it didn't exist. So other than that, I will rest on my
I think we have your argument, counsel. Thank
unless
you.
there's no questions.
No questions.
Okay.
Thank you. The next case on for argument, case 916, People versus Misano.
Good morning, Your Honors, and may it please the court, Sarah Goldfarb, on behalf of Mr. Joshua Misano. The trial court should have suppressed the evidence found after police unlawfully seized Mr. Misano without reasonable suspicion. The interaction here between Mr. Misano and police was a level 3 seizure because, first off, anyone in Mr. Misano's position would not
Counsel,
believe...
let me ask you this. Is your argument that it's a level 3 seizure, but that the facts did not provide for a level 3 seizure? In other words, I think we have a police officer, Hart, who does the observations from 50 to 75 feet away, half a football field away.
Correct.
And is it your argument that his observations did not amount to a hand-to-hand transaction?
That is correct, Your
Right?
Honor. Yes.
But when he relays that information to the second officer, whose name is escaping me right now.
Officer Young.
Officer Young, Connor Young. When he relays that information to Connor Young, he says essentially that he viewed a hand-to-hand transaction. So when Young comes in, is he now under the impression that an officer had told him that there was a hand-to-hand transaction? So he's acting upon information that would be a level 3, right?
I believe it was a suspected hand-to-hand transaction. I would need to confirm that with the transcript, but I believe he was told that it was a suspected drug transaction.
Does it make a difference if the reporting officer, Hart, what he tells him isn't accurate, that it isn't a hand-to-hand transaction? There's not enough there to qualify it as a hand-to-hand, which is your argument,
Correct.
right? Your argument is the defendant puts his head in the window, takes his head out, looks around. There's no hand-to-hand transaction visible. And the officer says it had, I think Hart's testimony was, it had some indicia or some indication in his mind of a hand-to-hand transaction, but I don't know that he saw enough to conclude that from half a football field away.
Correct. Hart, I believe, says that he just saw Mr. Misano poke his head through the window, then poke his head out, using his cell phone, and then, poke his head back in, but he never observed anything, correct?
So if we were to conclude, based upon the testimony, that there wasn't enough here to demonstrate a hand-to-hand transaction, where does that leave us?
If there's not enough to demonstrate a hand-to-hand transaction, then we don't have reasonable suspicion for the level 3 stop that was here. So
How does that
you would ask for
impact on the
suppression.
officer going and looking in the car window?
Well, so the officer who looked in the car window, Officer Young, he did so after elevating it to the level 3 stop by directing Mr. Misano to stand to the back of his car, telling him not to move, or.
So there's a
he didn't say
seizure.
that. So there was a seizure, and then he looked in the car window after it was a level 3.
In
which
other
he
words,
did
the
not.
defendant, in this case, could have, if there wasn't a seizure, gotten in his car, driven away, and there's no viewing inside the car at all.
Exactly, Your Honor.
Counselor,
Yes.
do you agree that the court found effectively attenuation between the frisk and the discovery of the evidence?
I don't agree with that, Your Honor. Or are you asking if I agree that that's what the court found, or
Correct.
whether I agree with his decision?
That's what the court found. I'm looking at page 6 of the decision. The court, I think, said even if Young did not have such quantum of knowledge, however, the subsequent frisk of the defendant yielded no items of evidentiary value. The people cite to Mobley, which I think is an attenuation case. So that seems to be where the court was going with respect to the frisk. Do you agree that that was the court's decision?
It sounds like that was the court's decision with regard to the. Do you mind repeating your question again?
I don't know. You're expecting me to remember it.
I know.
I'm just asking if you agree that the court decided, at least in part, on an attenuation theory, that is, that there was no discovery of evidence as a result of the frisk. I think that's what the argument is, if I understand it.
Right. So I guess correct. There was nothing found from the frisk, but I don't think that would diminish the fact that this was a level 3 stop.
Why not?
Why not? Because it was an ongoing situation. He conducted the pat frisk and then, immediately said, okay, you have nothing on you that would be harmful to us officers. So now you go stand here because we're still investigating this
The
suspected.
standing here is a direction that's the effectiveness of effectively a detention that's a level 3, irrespective of the frisk.
Irrespective of the
Just trying to
frisk,
get
correct.
the sequence in my head.
The way I view it is it was evaluated together because the situation was ongoing. They did the frisk and then directed him to stand in the back where a police officer was, watching over him. And it was conducted very, within a short period of time together.
Does the record revealed, was the defendant, according to the officers, was he free to leave after the pat-down?
No, he was not free to leave after the pat-down because immediately after the pat-down, he was directed to stand in the back by his vehicle, and Officer Young testified that, Mr. Misano would not have been free to leave after that
So
moment.
it's not like the seizure ended at that point?
Correct, the seizure did not end. It was ongoing throughout. And so, anything that Officer Young observed in the window in plain view after that was the product of that illegal seizure, that level 3 that, was not proper. If this court does not have any other questions, then we would just ask that you suppress the evidence against Mr. Misano, vacate his guilty plea, and dismiss the indictment.
Thank you, counsel.
Thank you.
Good morning. May it please the court, Caitlin Guptill on behalf of the people. If I could pick up Justice Whalen with one of your points. Detective Hart did transmit to Officer Young that he had observed what he believed to be a hand-to-hand drug transaction. At the lower level, at the suppression court and on appeal, nobody challenges the reliability of that communication, which I think would lend Officer Young with the requisite reasonable suspicion required to, one, pat frisk the defendant.
Would you agree, counsel, would you agree that once that reliability, relying on a fellow officer rule, right? That if Officer Young gets that information, relies upon it, and goes forward, you still have to go back and find out whether or not the officer that provided that information had a reasonable basis for providing it.
I believe if it had been challenged, then I think the reliability of that communication.
Wasn't the suppression hearing all about challenging that in terms of questioning whether or not they saw a hand-to-hand transaction? That's where the examination of the witnesses was all going to, right?
I think they questioned Detective Hart about his observations, but nobody asked Officer Young about the communication and about whether he reasonably relied on another officer's. And I didn't dig into it as much.
That's my question. Even if Young reasonably relied, say we agree on that, Young reasonably relied upon the officer's Hart's communication to him, don't we still have to go back and look at Hart and find out what Hart knew and whether that was really reliable information that he transmitted to Young. Would you agree that we have to do that still?
I think we're discussing in part, which I don't believe was in their brief or our brief, the fellow officer rule, right?
Right.
A communication from one officer to another. And I think that if this court was going to consider that, then at the lower level, the defendant would have had to have raised that in his omnibus motion, specifically challenged the reliability of that communication.
I don't think defense is arguing, fellow officer. I think what the defense is simply saying is there wasn't established at the suppression hearing enough information to demonstrate a hand-to-hand by Hart's testimony, which is a witness, between the defendant and the person sitting in the car. That there just wasn't enough there.
Right. If Officer Detective Hart was the one who had approached and detained the defendant, but he did not. He had relayed that information to Officer Young.
So what if we were to find that there wasn't enough evidence at the suppression hearing to demonstrate a hand-to-hand? What happens then?
Even if this court, I believe, even if this court finds that Detective Hart's observations were not enough to reach reasonable suspicion, he did convey enough to Officer Young to reach the requisite reasonable suspicion.
But is your answer, I'm thinking your answer seems a little different in response to the question asked by the presiding justice. You said if there's not enough to create reasonable suspicion. My question is, kind of piggybacking on the presiding justice's question, if there wasn't an actual hand-to-hand transaction, would it have been enough for Hart to have seen activity that could lead him to reasonably conclude that there may have been a hand-to-hand transaction, even if there wasn't an actual hand-to-hand transaction?
I think I understand. I believe that there was enough. I believe that what Detective Hart observed on his own was enough of, in a totality. We're talking about a sequence, and it's not just what he observed leaning in and out of the car, putting his head in the car, looking around, texting on his phone. We have this entire sequence of events that happens before they even get into the parking lot. So we're talking about Detective Hart's observations in traffic of the Mercedes, not the vehicle that the defendant was in, but the other vehicle that pulled into the parking lot of a closed business, repeatedly committing a vehicle and traffic violation, yelling to each other.
Let me just interrupt you for a second. Am I correct that Hart did admit that he didn't see the actual hand-to-hand transaction, but his testimony was that he saw all of these activities that led him to believe that a hand-to-hand transaction had taken place?
Yes, I believe his testimony was characteristics of a hand-to-hand transaction. And I cited in my brief People v. Nichols, which was a Fourth Department case from 2019, that even though they could not see the hand-to-hand transactions, they could not see what items were being exchanged, they had other observations similar to this case, right? In Nichols, they had the drug-prone area, packaging in plain view, the driver's furtive behavior, right? Though that's similar to all of Detective Hart's observations before they even witness the behaviors near the car. I think that there's enough here in the totality.
So you're saying look at the totality, but let me ask you this. If we were to focus on just what the officer testified to, and I understand your argument is you need to look beyond this, but if we were to just focus on what the officer testified to from his 50 or 75-yard vantage point, and that is, he saw, I think it was essentially, he saw the defendant exit his vehicle, go over to the other car where the person remained inside the car. He thought that that was an important point because that person in drug transactions want to be concealed, can't be seen in there from a distance, right? And the defendant stuck his head into the car, right, and out, looked around. The looking around was maybe looking for police officers, right? But when he sticks his head in the car, he doesn't testify, I don't think, that he saw a hand-to-hand transaction. So is it enough, would it be enough for that, what I just described, a person leaving his car, going to another car, sticking his head in the car, pulling his head out and looking around, is that enough for the police to reach a level 3 seizure?
No, it would not be enough on its own.
What else do we need, and that you have here? What amplifies this case so that we're not saying in the 4th Department, that's enough to seize people.
Right. What amplifies this case is all of that conduct that I described before.
So the officer watches the car kind of do some vehicle and traffic law violations, which
Yes.
would justify a pullover, but that doesn't happen here.
Correct.
Well, traffic law violations don't indicate a drug deal, right?
Correct.
Okay. There's some conversation between the driver when he's doing the V&T violations and another vehicle.
I don't disagree with you that if you view every single action in isolation, that that's going to get us enough. But when you take each of these things together and view them as a whole, I think you get to reasonable
That's the
suspicion.
case. That's what we have to do.
That is the case.
Okay. I think I understand.
The only other thing I wanted to mention, Justice Curran, was the pat frisk. I do, that Mobley case, that the pat frisk was attenuated from the subsequent view plain view from a lawful vantage point of the, what appeared to be cocaine on the front passenger console.
But you still agree it's a level 3 irrespective of the pat frisk, because he was detained behind the vehicle?
Well, I think there is an argument, and just briefly, there is an argument that they did have an objective, credible reason. It's different from that Hernandez case that's cited by the defense. The Hernandez case talks about pulling over, stopping a car, right? Here, these cars were already stopped. They were already parked in a parking lot. And I think that there's some debate about whether this is reasonable suspicion, a level 3, but we certainly have a level 2, an objective, credible reason. And to approach them in a parking lot where their vehicles are stopped. And from that lawful vantage point, they make observations in plain view. I think the driver's window is down of the cocaine on what appeared to be cocaine on the center console with the rolled up dollar bill. So I believe the pat frisk is attenuated. And that, there is an argument that that is a level 2 at that point. There was no evidence that was recovered from that pat frisk. And
Is it your argument that after the pat frisk, there was no longer a seizure of the defendant in this case? Is that,
They did
so it's
ask-
a level 2 and they can look then inside the car?
it's my argument that the pat frisk not should be viewed separately, but that they didn't handcuff him. They asked him to step to the back of the car.
The officer said he wasn't free to leave though, right? He wasn't free to leave.
Correct.
Yeah. He was seized.
I can see that he would be seized at that point.
Okay. Thank you.
Thank you.
Case 918 and 919, Tretz versus Zawicki.
Good morning, Your Honor. I'm Charles Greenberg, representing Elijah Tretz. Before I begin my argument, this case, of course, is a very unusual posture to the judges. Any have any questions you would like to ask?
Proceed with your argument, counsel.
Okay.
Well, we'll interrupt you with questions if we have.
Okay, good. Well, this case, as I pointed out, does come with unusual posture because it was integrated with the family court was integrated with the Hamburg Town Justice Court, and Justice Montour, who was the judge presiding over the case when he was at the trial.
We're familiar with Justice Montour.
Yes. Made the decision to transfer custody or to grant sole custody to Ashley without a hearing, so we would ask that that decision be reviewed and sent back for a hearing on that issue.
No further questions. Counsel, thank you.
Thank you.
Case 921, Dickies versus Johnston.
Morning, Your Honors. Kathy Reardon for Appellant Nicole Johnston. We're asking the court to reverse and vacate the family court's order here and put the 2016 order back into place, giving mom primary residence of the child. The court failed to make a determination as to any change in circumstances, and the record doesn't support any such change. Mom continues to be primarily responsible for the child's medical and educational needs. It's borne out by the testimony. The father mostly relegated those needs to the mother in any event. If anything, we would request that he get less time And also note that the court's determination regarding the Lincoln hearing, that the child may have been coached, we find that there's definitely an issue with that because the AFC repeatedly told the court prior to that in fact the child wishes to spend most of her time with the mother. So we're asking that you remand it for a determination for the change of custody, or excuse me, the change of circumstances. We're also asking the court below to review mom's petition for sole custody based upon all the evidence presented at the trial.
Thank you, counsel.
Good morning, Your Honors. May it please the court, Maureen Poland from the Legal Aid Society of Rochester here on behalf of the child. Our argument is similar to that of the appellant mother. My client maintains to this day that her preference is to have more time with her mother than with her father. She has been living with this shared residency schedule for a little over a year now. Her position remains the same. Having shared residency hasn't changed anything for her in terms of what her preference is, which I think strongly calls into question the trial court's finding that her Lincoln hearing or her in-camera interview was in some way coached or rehearsed. So we would be arguing, as the appellant did, that the court erred in failing to determine whether there was a substantial change in circumstances such that a change was needed to the custody and parenting time schedule. We would be asking the court to reverse and remand and for the 2016 order to go back into place while the lower court makes a determination on any remand. Does the court have any questions?
No questions, counsel. Thank you very much.
Thank you.
Case 922 in the matter of the arbitration between Syracuse Firefighters Association and the City of Syracuse.
Good morning, Your Honors, Counsel, and may it please the Court. Liza Magley, Bonchenik and King for the City of Syracuse. The City of Syracuse and the Syracuse Firefighters Association have a history of collective bargaining and engaging in counseled arm's-length negotiations to enter into collective bargaining agreements. The clear, unequivocal collective bargaining agreement here is no exception to that tradition. And the language of that agreement mandates two inescapable conclusions in this case. First, that the arbitrator exceeded her limited powers by even considering the purported grievance after the association failed to comply with the express time limitations enumerated in Article 19 of the CBA.
Was that an issue for the arbitrator to resolve?
We believe that it was an issue for the arbitrator to resolve in the course.
The arbitrator resolved it adversely to you?
That's correct.
By construing it to be timely based on when they learned it by virtue of some other cases involving this release?
That was one reason why. The arbitrator also relied on secondary sources and looked beyond the four corners of the agreement, which we would say was unnecessary in this case. The language is unambiguous in Article 19, Section 3. It states that the grievance is considered waived if you don't bring it within 30 days of the event. There's no tolling language, there's no discovery rule, and these entities are counseled parties who have done this, time and time again. If they meant for that sort of language to be in the agreement, like in the Henry Adirondack Beverage case that we cite in our briefing, then they would have included it. So for the arbitrator—
What's our standard of review with respect to the arbitrator's determination that it was timely?
What is the standard of review? It is that, if she irrationally went beyond the limits in the arbitration agreement, and in this case, we would say that she did.
It's a very deferential standard.
It certainly is. We would not, all the parties agree with on that point.
Well, and it has to be totally lacking in any support in the record as well, correct?
It does, and we would say that it is because the agreement itself is clear, and looking beyond the agreement in and of itself was beyond the scope of the powers that she's been enumerated under the agreement's very terms, which right in 19.2, the provision right before, says that the arbitrator cannot amend, modify, etc., any of the provisions in the arbitration, in the grievance procedure, which by reading in a discovery or tolling rule, she did. With respect to the second point, even if the arbitrator could have considered the grievance, it's our position that the arbitrator conflated the two forms at issue here. The form that Wellnow uses as the fire physician is not the same as the initial determination decision form that the chief uses according to Appendix C, Section 4. The fire physician is relegated certain enumerated tasks, and this isn't one of them. It states that the chief is the one that uses the form that's discussed in Appendix C, Section 4, and the chief's form, all the parties agree, does include the correct language. It's not asking for anything beyond that which the contractual language requires. So by reading into the contract, again, that the Wellnow provider, this third party that the city has no control over, is required to use the same form that the city itself uses, is again an irrational construction of the very language of the agreement that these parties.
Who selects Wellnow?
The city is the entity that selects the fire physician. And the city certainly did, as the record reflects, seek a change in the form. Wellnow refused. The city can't control what the third party's form states, and the form the city does use is compliant with the terms of Appendix C, Section 4. And as we indicate in our papers, to find a new provider is going to create some issues for the city and for the firefighters themselves that...
Yeah, but that's not really part of this, correct?
Well, it's something worth, considering, though at the end of the day, you're correct. The standard of review is whether the arbitrator applied a rational construction of the party's terms and whether the arbitrator, went beyond her duties under the collective bargaining agreement. And if the court has no further questions at this point, we'll rest on our papers.
No questions, counsel. Thank you.
Thank you.
Nathaniel Lambright, Blibben and King, for the respondent. Briefly, very briefly, the standard is whether the arbitrator's decision was irrational or violated public policy in any means. It certainly was rational. She interpreted the grievance procedure in the 30 days to begin when the grievance was discovered by the union. For the court to get involved in second-guessing the arbitrator, I think that would be inappropriate based on Court of Appeals precedent. Similarly, with respect to whether or not the arbitrator was irrational when she concluded that Wellnow was acting within the city's shoes, that certainly was rational. Each of the arguments that the city is bringing up today were brought up before the arbitrator and not resolved in the city's favor. Finally, I discourage the court from adopting what is clearly the city's tact of saying, let's catch us if you can, in the sense that if we can hide a grievance for 30 days, somehow the city would get off the hook. She did speak about council parties. I've been working with Local 280 for 22 years, and this is certainly how grievances have always been resolved. We grieve them when we discover them. And with respect to the continuing violation, she also brought that up as a second grounds, which I would discourage the court from seeing as a reason for vacating. So if there are any questions, I think...
No questions, counsel.
Thank you.
Case 923, Slamba versus Klepp.
Morning, Your Honors. May it please the court. Donna Burden on behalf of Evans Center Volunteer Fire Company. The real issue in this case is whether a volunteer firefighter in her personal vehicle in street clothes, attending to the business of the fire hall and going to a training session is covered under the general municipal law, and I submit to you that it is.
Well, I think your opponent probably doesn't disagree with that. The question is whether that's established from your perspective as a matter of law, or whether there should be some discovery on that issue.
The notice of claim requirement is a condition precedent. There's no discovery that a claimant is entitled to in preparing to decide whether or not to file a notice of claim against a
No,
municipality.
that's not what I'm saying. I think that the real question is whether the defendant, Ms. Klepp, was actually engaged as a firefighter at the time. And your opponent says that there's been no discovery. There are conflicts as to some of the proof that, on which you rely to establish that she wasn't engaged as a firefighter at the time. For example, the police report makes no mention of the, who was it, the fire chief or the, yeah, the assistant fire chief who allegedly stopped at the scene. There's no mention of him at the scene. And the plaintiff herself said he didn't come to the scene. And so I should be at least be allowed some documentary discovery to find out about this training session. I should be able to question the fire chief. I should be able to question the police officer to establish whether there's a question as to whether she was, on a personal errand or not.
Your Honor, in terms of the police report, police accident reports are filled out by the officers at the scene.
Mm-hmm.
I've never seen them address where a defendant or a driver is coming from or going to. I believe there was only
apparently this assistant fire chief spoke with the responding police officer, and there's no mention of that in the police report. And what you say may be true, but the question for us is it just too early for us to make this determination as a matter of law?
Well, I don't think it's too early because the police report would not have included that information. If we look at the police report, it doesn't even mention that the plaintiff in this case sustained any injuries at all. If we look at the police report, it doesn't make any mention of any emergency response personnel. It doesn't make mention of any statements given by any of the drivers to the police officers. They generally don't. When someone has a notice, they're specifically on notice that a municipality is involved, they have an obligation to serve a notice of claim. In this case, it wasn't done, and there's a lot of reasons why USAA was defending the case.
Originally, right?
And originally, and Hillary Banker advised plaintiff's counsel, someone's going to be taking over for the Evans Center Volunteer Fire Company. The carrier is primary. That was all solidified. It's all in the record as of...
What if Ms. Klepp was not traveling to this training exercise?
At the time of the accident?
Yes.
It wouldn't be covered. It wouldn't be, because the insurance carrier would never have picked it up. In order for the insurance carrier to pick it up, you look at where is she going and for who is she doing it. She's a volunteer firefighter. She's going to training. So the fact that it's her personal vehicle, the fact that she's in her regular clothes doesn't matter. And she's going there. So the insurance carrier said, okay, we looked at everything. There's no reservation of rights in terms of their coverage. There was no reason for her as of April, I think it's April 20th, not to serve a notice of claim. And then April 27th, Hillary confirmed in writing the carrier for the volunteer fire company is going to take over their primary. She should have known then. And then when we appeared June 8th, the first thing I do is look at the file. I look at the answer. Okay, I need to add in the affirmative defense. I know it's the condition precedent. I really don't need to amend. I'm raising a flag. You're on notice. COVID, the governor extended the time. She had 3 months from when Hillary told her.
My question is, I understand that, and it very well may be that that ultimately it's found that she was in the course of her duties, right? And then your argument's going to be, they had plenty of time. We put them on. We tried to help them. They never filed a notice of claim, and therefore you'd be, it seems to me, maybe in a pretty good spot. But the first question has to be answered, and it has to be answered in a way where counsel has an opportunity to explore that. And that's the question Justice Perodato was raising. You say that the information that Justice Perodato was raising isn't normally found in a police accident report. I think that's probably right. But does that preclude plaintiff's counsel from finding out whether or not what her status was in the car at that time? In other words, was she going from point A to point B en route to the training facility? Or did she leave to go run a personal errand? And it seems to me that depending on how that question's answered, may determine whether or not the fire company's policy is implicated or her personal policy is implicated. Am I wrong about that?
Well, Your Honor, I think that the notice requirements is to give the municipality a heads up in their investigation and discovery. Now, we know it wasn't done, but the year and 90 days was still there. If she had filed the notice of claim or served it, we would have had an opportunity to conduct our 50H hearing, which is the entire purpose of it. Instead of doing that, she says, I want to go down that rabbit's hole. So here we are another year later, and the judge said from the bench that she would allow discovery as to whether or not she was in the course and scope of her duties. But then in the order, she didn't put that in the order. So the plaintiff wants to do all the discovery. The purpose of the notice of claim is to avoid that unnecessary discovery.
But you have the ability, I mean, if in fact the court rules for the bench and you're not happy with the order, you can go back and ask the judge to amend the order based upon what was said. And in other words, if the order was maybe not drafted the proper way, there's a remedy for that that's not before us, right?
Right, it's not before you. We did submit that proposed order, and she did not sign that proposed order.
She denied, okay. So let me ask you this, this is a motion to dismiss.
Yes.
Right? Yeah. And so the whole question before us is whether or not factually you've demonstrated as a matter of law, right? And that's where we are. And the issue here is, were there questions that need to be explored? The court below said limited discovery ought to be had.
But the order doesn't say limited discovery.
I understand.
And that's part of the problem. We're going to do all of discovery to get back to this point and be before the court again to say she's driving for the fire company, going to training. There should have been a notice of claim and there wasn't. And they knew that.
Remind me, do you concede that there should be some limited discovery?
No, I actually don't, Your Honor. I don't think there's any entitlement to discovery as to whether or not someone is entitled to a notice of claim. There's no precedent for discovery as to whether someone...
Part of your argument is the carrier for the fire company took over the defense.
Without a reservation of rights.
Without a reservation of
That's
rights. Based on its conclusion that she was engaged in firefighting activities at the time, and from your perspective, that should be enough.
That should be enough. Because an insurance company is not going to do that if there's a question of fact. There would have been a reservation of rights. As of April 20th and April 27th, they were on notice. There was like 90 days. She had 3 months to serve a notice of claim and did not do so. So for those reasons, unless there's any other questions, we ask that the decision and order be reversed.
Thank you, counsel.
Good morning, Justices. Joy Ellen Miserandino for the respondent, Renee Slamba. I'm sorry. With respect to Judge Penapento's order, we went back and forth a number of times, and the judge specifically chose the order submitted by the plaintiffs. This has taken a very unusual gotcha course of discovery. The affidavits that came in with respect to witnesses at the scene, we did not receive until well after the COVID extension. As you justices are aware, when you bring a motion to file late notice of claim in a motor vehicle accident, if notice and prejudice to the municipality is very important. And in an MVA, it has been held over and over again that a simple police report does not give notice. We have had discovery where we were told there were no witnesses, there is no excess coverage, would not respond to whether she was working at the scene. And all this information came in after our time to file our motion. So if we're looking for a motive as to why they took over, that's my motive. And I think equitable estoppel can come into play in misrepresentation. But Judge Peredato, the fact is that's not the issue here. I have been working in this business for 30 years. And one of the primary duties of the police officers is to list witnesses and to list who's at the scene. And I have over and over, especially when statements are made to them, we have a conflicting set of stories here. What if she had decided that she was going to go home and grab a sandwich and then she was going to go on to the training, or it was optional to go? I think it's very relevant that the police chief, apparently, I have very limited knowledge, I have no depositions, was way behind her. And he was the one running the program. He didn't show up at the scene until well afterwards. So where was she
Talking
going?
about the assistant fire chief.
Yes. He showed up at the scene well after. So what was she doing? Was she going to go and sit outside the building? I mean, there's just so many factual discovery issues that we have not been allowed to pursue.
Let me ask, counsel, your opponent raises an interesting question. She says that to allow for full discovery in a personal injury action, when the focus here ought to be, if there's any, not that your opponent's conceding this, but it should be just on, was she in the course of her job? And if she was, then a notice of claim is required. If she was not, then a notice of claim isn't required, right? It seems to me that that's the limitations, but the order that's before us does not limit the discovery in that fashion, and isn't that a problem?
I don't think it's a problem because the colloquy of the court in her decision was that, can you please work it out? I'd like to keep it limited. That the court tried to contact us to set a pretrial saying that it should be limited.
But in the end, it's the language of the order that controls.
It is, but I think that when we have an issue and we go before the court, because the court specifically said to pretrial, we don't want you to go into damages. If you can't agree on what the parameters of the depositions will be, you're going to come back before us and we'll set them. So I don't really think that the order is in contradiction. It's basically that it's premature and discovery should continue. And just to sum it up, if there aren't any questions, I would respectfully ask that the lower court, who has been very involved in the discovery process, order denying the motion be confirmed as premature and the discovery continue.
Thank you, counsel.
Thank you.
Case 924, Cayuga Nation versus the Town of Seneca Falls.
Good morning. May it please the court, Lee Alcott, Barclay Denman, Syracuse, on behalf of the appellant.
Mr. Elkin, if I read your brief correctly, you're basically saying the court sort of jumped the gun here and dismissed the DJ action under Article 78. The two are different animals, so to speak, and we're supposed to defer to your allegations of the complaint and go from there.
That's it. The only thing I would notice, and I read all these cases, there seems to be no bright line for standing when it comes to distance. 100 feet, 300 feet, 1,500 feet, 1,800 feet. Okay? The Burgesses have lived 33 years in this house on Cayuga Lake. It's a beautiful, idyllic home. Right down the street, they have this shack, and it's not selling corn, it's not selling tomatoes, it's not selling apples, it's selling marijuana. And the cars pile up, and the cars go up and down the street. And we just think, special term, jump the gun. They knocked it out on standing, never gave us, my clients, a chance to go forward.
Thank you, counsel.
Thank you. We ask the order be reversed. Thank you.
Case 925, Waddell versus Milwaukee THP LLC.
Good morning, Your Honors. May it please the court, Mike Kutu of Lewis & Lewis on behalf of Plaintiff Francis Waddell. And it is our contention that the court below erred not only in granting the defendant's motion for summary judgment in this case, but in denying plaintiff's motion for summary judgment on the issue of liability in this fall down on dangerous and defective stairs case.
Okay, and isn't really the center of it causation? What proof is there that the stairs, which were not beautiful, okay, actually caused the fall? Why don't you tell us what you've been able to put out for us?
Thank you, Your Honor. I think that is the crux of the dispute between the parties here as to whether or not either burden was met on the question of causation. And here what you have is a fall that occurs on crumbling stairs, right? You have not only plaintiff's testimony that she is not sure of what caused her foot to slip, right?
And in fact, she said that many times, didn't she?
She did.
Okay.
She did, there's no doubt about it, right? But there is other proof beyond that that supports a reasonable inference that it was the stairs and nothing else that caused the fall.
proof?
The proof includes where she was in relation to the defective stairs, right? She's found right at the bottom of those stairs by her daughter moments after the fall.
But given her deposition testimony, how can she survive a motion to dismiss at the end of the plaintiff's case when she says, I don't know what caused me to fall? Yeah, I see these photographs. I don't know what caused me to fall. So isn't that the same standard we apply here on summary judgment?
I don't think so necessarily, because at her deposition, right, and we get into the idea of the photographs and the affidavits that are submitted as well, but the photographs themselves were already admitted through the testimony of the daughter and her son-in-law who took them. The son-in-law took them within an hour of when
But
she fell.
how do we make the inference that the condition of the stairs caused her fall?
I
mean, just because she's near them, I think is probably, that's what I heard you say earlier, just because she's near them. I mean, it seems to me that that a jury would have to speculate that, you know, either she misstepped, which is a possibility, or she tripped on those crumbling stairs or whatever. It seems to me that you need something else to get the inference that you're looking for.
Well, I think a couple of things, and getting back to both Judge Curran's question and your question as well, Justice Perdomo, at the same time, I think the fact that here she has not only the proof what she knows and what she remembers, what she can testify to, right? But you don't rely solely on that, even if she doesn't know. You have cases where folks fall out a window and are found underneath it, right? And you have the obvious nature of the defective condition in those cases. And in those cases, the courts are saying, well, it's a reasonable inference that it is the dangerous and defective condition.
But in that situation, if the plaintiff testified after falling out of the window, allegedly, I don't know how I got here. Isn't that the end of the game? That is, otherwise the jury's speculating as to how the plaintiff ended up on the sidewalk.
I don't think so, Your Honor, because I think with the proximity, right, at some level, is there a distance? It may get too far, but when you fall right at the bottom of crumbling stairs.
So is your argument that, you mentioned the window, and I'm kind of intrigued by this argument. Your argument is if a person falls out of, say, a second-story window and is knocked out and then is asked, how did you get here? And they don't know, but they can show the window is broken. Some kind of force was leaned against it, snapped, and they fell. And you're saying that might be enough to have an inference that there was something about the window that caused her to fall through that very window to the ground, and she doesn't remember. That's interesting. But that's not this case, right? This case, we have some crumbling stairs, but that's not, it strikes me as, it's very possible she could have walked down the stairs without a problem and misstepped on the last step, which is on the ground. In fact, there was some indication in the record that may have been what she was saying initially. So if we have to speculate, just in other words, if you're saying we're going to rule that as long as there's a defect that we can see in the stair and she fell near it, that's enough to get to the jury on the issue of what caused her to fall. That, to me, is a little different than the window example.
I think it's a very close example, but I can see where Your Honor is going with that. But here you have more than just the vicinity as well, right? You have...
But also you have her telling the EMT that she misjudged how many steps there were. She says nothing about crumbling steps, but she says, no, I just kind of misjudged.
A couple things on the 3 pages of medical records that aren't in admissible form, which were submitted by defendants in support of their motion, right? Those are the records, I believe, from the EMT service. Because what happens after she falls, she's picked up by her daughter, taken to urgent care, and then is later transported to Mercy Hospital for surgery. And what you have in those records, I don't think they should be considered, right? They're not in admissible form, okay? There is no indication that how a fall occurred is germane to treatment, which
They're
could...
hearsay. they're hearsay for sure, okay? Secondhand account of what happened, all right? So what else do we have left? We have, you presented to us what the daughter said, the mother said to her. That's also the same defect and hearsay, isn't it?
Sure, it's hearsay other than to the extent that that was also said at the medical facility, to the extent it's challenging what they're bringing forward. It's also the observations of Courtney when she was at the scene and could see where the fall occurred and could see what would have caused that fall.
She didn't witness the fall.
She did not see the fall, no. But if you come across something, can you make a reasonable inference, just like any jury can, about what happened based on crumbling concrete right here? In fact,
I would say to you that if we had something like pieces of the concrete in the sole of her foot, or pieces of, just maybe a scene where the concrete is underneath her, there's something else. But I'm concerned, as some of the questions have indicated, that there's just no connection other than it's nearby and it was defective. And I think you're saying there's more to that, and I'd like you to give you an opportunity to tell us what, other than what you've already told us, we should rely on.
Sure. If you look at what was marked as Exhibit 9 back at plaintiff's deposition, which is in the record in 2 locations, it is at...
Well, just tell us what it is.
It is the photograph that shows the stairs, right? This is one of the photographs taken shortly after she fell, okay? And you can see, and there's a couple close-ups in the following photographs, and you can see freshly crumbled concrete right here, and she's found right here. You can see there's even crumbled concrete on top of snow, right? Indicating that probably pretty recently occurred, right? Are you speculating? No. Is it a reasonable inference that that recently occurred, right? And that that's the cause, or a cause, a substantial factor in her fall? The other thing you have beyond the photographs showing the condition of the stairs is you take a step back to, well, how about the failure to warn and to close off those stairs in the first place? She never should have been on those stairs,
So,
right?
counsel, let's say we agree with you that those photos show a bad condition of those steps, okay? But what do you have in the record to show us that that condition was the cause of her fall? And that's what we're struggling with.
Right, well, even, right, the point I'm making, I think, or trying to make and trying to articulate, and maybe not doing the best job in the world doing that, is she never should have been on the stairs in the first place. They'd had these guarded off before, right? And she approaches the stairs that night, and there's some portion of the walkway to her left, which is covered in snow or covered in snow and leaves. So she chooses to go up the stairs in front of the vacant storefront, okay? And even if you misjudge your step coming down stairs that should have been cordoned off in the first place, you never would have got there. So it's the failure to maintain the property and the failure to warn, which is a proximate cause of the injury, regardless of what happens here, leaving any question as to whether she misjudged a step, simply a question of comparative fault, not breaking the causal nexus between blocking that off or putting a warning up in the first place. I think
Counsel, you should begin to wrap up.
Yeah, sure. I think with that, unless the court has any further questions, I'll rely on our papers.
Thank you, Counsel.
Thank you.
May it please the court, counsel Tom Cunningham on behalf of the property owner, Milwaukee.
What about that photo that he just showed us that shows part of the crumbling step on the snow right in the area where the plaintiff fell? Is that enough to create an inference that the condition of the step may have been a cause of her injury?
No, I don't think so, Judge. In your one of the first questions, I think it was Justice Bannister's question, was the causation issue. What's the causation? So in this case, looking at the facts we have in this case, she testified she comes down the stairs, her right foot, she mixed up her feet at one point, let's just say the foot that is on the ground. She plants that onto the sidewalk. At that point, when she plants it onto the sidewalk, her ankle rolls and twists. Her other foot is on the stairs. I asked her, was your foot still on the stairs? Why did it come off the stairs? It came off the stairs because she twisted her ankle. So the idea, and I think she then uses an affidavit, which I don't think is admissible in this case anyway, to create an issue of fact. Part of their argument is, well, the stair crumbled. Well, we know it didn't. That didn't cause it because we know her foot planted, her ankle rolls. Now her foot's on the ground, not on the stairs, and then her other foot comes off. So we know that the stair itself could not have been a causal factor in this case. So we can rule the stairs out completely. Now the second question...
Let me just stop you there for a second, counsel, and to follow up on Justice Paradato's question. If in fact part of the crumbling stair was on the ground and she plants her foot and her foot twists, how is that not a jury question to determine whether or not that contributed to the happening of her foot twisting?
So the second part of this is, she testified, I put my foot down, I plant my foot on the sidewalk, and I twist my ankle. She doesn't say, I put my foot down, I felt something underneath my foot. I put my foot down, my foot rolled on something. No, what we have here, and whether we consider it admissible or not admissible, is the idea of a misjudgment of a step. You could say, yes, maybe it's hearsay. First of all, the plaintiff produced that to us. That's how it got in the record. So I think it was properly in the record. But if you consider that to be a hearsay statement and the exception of it being an admission and a record of treatment, okay, consider that to be a hearsay, let's just say. Well, we still have to come forward with an argument that this accident, because she says she doesn't know how it happened. She doesn't say my foot rolled. She doesn't say my foot stepped on something. She simply says it twisted. So what's another plausible explanation? We see that in other cases too, and we see that in life. She thought that she was already at the bottom. She misstepped. So when she comes down that step, she thinks she's walking across a flat surface, and instead of walking across a flat surface, her foot hits down, and that is, the misstepping is a plausible explanation.
So you're saying, based upon her testimony, assuming, that's what we have, her testimony,
Yes.
that it would be speculation for a jury to conclude, and speculation for the court to conclude on a motion for summary judgment, that the crumbling that we see in the picture contributed to the happening of the accident.
Correct. We have nothing to tie that together in causation at all. There's no crumble in her foot. The daughter didn't say, hey, look, I looked at the sole of her foot and she had this in it. All the daughter says is, I found her at the bottom of the stairs, which, based on the testimony, could be she misjudged a step, she missed a step. I mean, that happens in life all the time. The idea, there wasn't any questions of me on this, but the idea that it wasn't in good condition, it just should have been roped off, well, that's a but-for. That is not causation. So it's not, if you would have just done this and she wouldn't have taken this step, that's no different than if I hadn't got up today, I wouldn't be making this argument. That's no causation between the two. So it's not legal causation. It might be but-for, but that doesn't apply. So the whole idea that this should have been roped off, if it was roped off, she wouldn't have misstepped. Well, our obligation isn't to protect her from everything she does in life. So the fact that there wasn't a roping off.
Even for the failure to warn, there has to be causation between the alleged defective, the condition and the accident.
Better put than I was. And second, we weren't under an obligation to warn us to the number of steps. We wouldn't have to say, hey, look, you might not be on the last step here. You take another look. I also have are there any other questions of me on the main? Nope, I also have an appeal on the third-party action. I think it's pretty well defined. I'll rest on the papers unless
Very
there's
good.
a question.
Thank you.
Thank you.
All right, good morning, Your Honors. Dan Sircone for the third-party defendant respondent, TC Notaro. Regarding the plaintiff's claims, I don't have too much to add after what Mr. Cunningham mentioned. I do think it bears repeating, though, that what the plaintiff's testimony was that this is essentially like a trapezoid-shaped stair. So she approaches it, she sees a pile of leaves with a dusting of snow. She says this is less than an inch of snow. And my client had observed the same thing and in the photographs and thought, yeah, that's probably less than an inch. So she had seen that, thought, this isn't dangerous, I'm not concerned about this. Also, here's some stairs next to me, which is also not dangerous with no concern. And even though she didn't think that there was a problem with the leaves and the snow over it, she still chose to use the stairs. She testifies as she ascends the stairs, gets to the apex, and as she descends, no snow, no ice, no crumbling condition, nothing she thought was dangerous or hazardous. And after she descends, and as Mr. Cunningham pointed out, once her foot is on the ground, she falls, doesn't know why. This means there's also no snow on the ground that she noticed after she fell near her. So it's not that she slipped on snow, slipped on ice, or tripped or slipped over some rocks or anything. There's absolutely no evidence of that to tie that, as we've discussed. So I think it bears repeating that regardless of who had the duty, which gets into third-party complaint, without the snow, ice, or stairs, as plaintiff's own testimony ruled all three of those out, there's no allegation left for the plaintiff to establish any causation. So to turn to the third-party complaint, there are really two arguments regarding the language of the contract in terms of whether Notaro would have to indemnify the third-party plaintiff. That's first, if the plaintiff's fall arises out of the performance of the services, meaning Notaro's services under the contract. Again, there's no evidence here that that occurred. It's not that Notaro was in the midst of shoveling or that they created a condition or anything like that. They had taken care of the lot in terms of plowing. They took care of the sidewalk, had no duty over the stairs, and even then, plaintiff said there's no problem with the stairs. The second option for indemnification is if there were some acts or omissions by the contractor, which could be considered to have attributed to the fall or the accident or any dangerous condition existing, which again, we know there were none. There's no testimony or evidence or anything to show that Notaro did something or neglected to do something which could have created any condition, much less one that could be causally related to the plaintiff's accident. And with that, if the court has no questions, I'll rest on my papers as well.
No questions, counsel. Thank you. Case 926, Chodak versus Shunk.
Good morning, Your Honors.
And counsel, my apologies if I mispronounced your client's name.
I believe every judge who has seen this file has mispronounced it at least once throughout the course of this entire litigation. I've done it myself a few times. It is Gary and Karen Chowdick.
Chowdick. Very good. Thank you.
And I am Carrie Byer, Law Officer Francis Litro, appearing for the Chowdicks this morning. Your Honors, there are two umbrella arguments that I'd like to address today. While we request that you reverse the final judgment that was filed against my clients earlier this year after a jury trial based on several legal errors committed by the trial judge during that. First and foremost is going to be what I will call our Johnson v. Lutz issue. This is a very short...
Mr. Byer, my concern on that is twofold. Number one is, how is it preserved? As the defendant pointed out in the brief, there was no objections to the testimony as it came in. And secondly, isn't it harmless error given all the other testimony that came in from the plaintiff himself about how snowy and slippery it was? Upon your direct examination of the defendant repeatedly testified it was snowy, it was slippery, and all the officer ultimately said was that there was slippery pavement. So twofold, how is this preserved, if at all? And secondly, isn't this harmless error?
To your first point, it was preserved because the plaintiffs did make three separate objections to this testimony to allow the trial judge to evaluate these legal issues and make a ruling. First, in our motion in limine, the only motion in limine in this case, we asked the court to preclude this exact testimony and the police report based on the Johnson v. Lutz issue. That's number one. Number two, Officer LaFalce appears at the trial and we conduct a voir dire at the trial court's
As
allowance.
part of the motion in limine.
I believe that's correct. We moved in limine, the judge waited for the voir dire. We completed the voir dire, and the important testimony during the voir dire was that Officer LaFalce, although trained as an accident reconstructionist, testified he used none of that training to come to his conclusion.
Just on preservation, it's all, if I understand your argument, everything relates to the motion in limine that was decided before the jury heard the proof. That's how you say you preserved it.
That's one, and the second is before he actually testified at trial, we renewed our objections, specifically as to the police report, not only to the narrative section, which Judge Ward did preclude, but also to those contributing causes boxes. In the top right corner of the police report, there's
So your argument is there was an ample airing of the issue before the trial judge on the admission of the police accident report specifically?
Yes.
And the court ruled that that will go in with some redaction?
Yes, but not complete redaction, which is what we had requested, as well as the objection to the testimony, because the testimony was the same as the information.
What about Justice Kern's harmless error issue?
I would say two things to Justice Kurtz's harmless error issue. First, it's clear from the case law after Johnson v. Lutz that this type of testimony cannot be considered harmless error. Ever, due to the inherent nature it bears on the ultimate
What about our
questions.
Christopher case on that exact issue where we found it was harmless error?
If there was some other corroborating evidence based upon the officer's testimony, I think the problem here, Judge, is that you talk about the extensive testimony about snowy and slippery conditions from the plaintiff and from the defendant himself. What is ignored is that part of Officer LaFalse's testimony was that the defendant's speed was not a contributing cause. What we have here is an admission. This goes to our second umbrella argument, by the way.
But
that the defendant
cross-examination with the officer, I guess that's where I'm really troubled on the harmless error, Mr. Byer. Just to go back to it, the plaintiff testified about how slippery it was. The defendant, on your questioning, repeatedly said his wheels locked up, he skidded on the snow. And then in cross-examination by you of LaFalse, the officer, you brought out, hey, wait a second, you could have charged the defendant here with traveling unsafe under the conditions. And you could have charged the defendant with following too close. So you brought that out as part of your cross. On balance here, isn't this one singular error harmless with respect to the testimony about the, box number 20 as to what 66 or 69 means, etc.? That's really it.
I would say no, it's not harmless error, Judge, particularly because if we believe that to be true, that the testimony, the overall testimony was that there was slippery and snowy pavement for a long period of time, that would mean that we should have been granted directed judgment based on Caristo v. Sanzone. But because that question of fact existed, then that means that the officer's testimony was harmful to the plaintiffs. It's a choice here. Either there was a violation of Johnson v. Lutz and there should be a new trial, or it was harmless error, at which point we should have been granted a directed verdict under Caristo.
So as to the testimony with respect to the error, it's just the testimony of the officer with respect to the 66 in the box pertaining to apparent contributing cause of the accident, right?
It's not the only thing, Judge. He also testified that the defendant's speed was not a contributing cause, which stands in contradiction to the defendant's admission at trial that he was driving too fast for the prevailing conditions and that his excessive speed was the reason that he collided with the rear of the plaintiff's vehicle.
But in your brief, you didn't really identify what testimony you wanted us to rely upon to find error. That's what I'm trying to sort out. I thought it was just the police accident report testimony by LaFalse. You're saying there's more than that?
There is more than that, Judge. Yes, in Mr. Schule's direct examination of Officer LaFalse, he brought out testimony from Officer LaFalse that the defendant's speed was not a contributing factor. That was a major issue at trial. As I said, when the defendant himself testified that he was driving too fast for the conditions and that his excessive speed was the reason.
I'm sorry to interrupt again, but was that part of your motion in limine with respect to the speed? And if
No,
it wasn't, then there was no objection.
The excessive speed, it was part of the motion in limine because we moved to preclude all testimony as to the officer's opinion as to the cause. The unique issue, and this is going into the second umbrella issue, the defendant changes his testimony at trial, presents new admissions during the trial testimony that didn't exist in his deposition testimony, saying that he was driving too fast for the prevailing conditions and that his excessive speed was the reason that he collided with the rear of the plaintiff's vehicle. That was new. It was a very dramatic moment at trial. I believe Justice Ward even acknowledged that on the record. We immediately moved for a directed verdict based on that admission and were ultimately denied. This is where it's been a problem. This was a short trial. There were 3 witnesses. There was the plaintiff, the defendant, and there was Officer LaFalse. If you look at just the plaintiff and the defendant's testimony in this case, based on the defendant's admissions, the plaintiff should have been granted a directed verdict. It was the 3rd witness, the tiebreaker witness, Officer LaFalse, coming in and testifying that the defendant's conduct was not a contributing factor, that somehow alleviated the defendant's own admission during his direct testimony. It can't be harmless, Judge, when the defendant's admission would have granted us the entire trial, to have that be the only tiebreaker to come in. So as to point 1, we would also acknowledge, of course, that the trial judge made inconsistent rulings. He precluded some of the police report, but not all of it, despite all of it being based on the same foundation. There was no foundation. We cite to the Silverman case, v. Sciritelli. The defendants never elicited any expert testimony, actually, during the direct, a reasonable degree of certainty in the field of accident reconstruction. But turning to, because we've been talking about it quite a bit, our second umbrella argument, which is that based on the defendant's testimony in trial, this new admission, particularly as to speed, his emergency defense should have been dismissed as a matter of law. And in that case...
Because the emergency was of his own making.
Exactly right, Justice. Yeah, it's the Marsicano case. When he comes in and says, I was driving too fast for the prevailing conditions, that eliminates his right to assert this emergency defense. The parties have agreed, defendants previously conceded that but for this emergency defense, plaintiffs should have been granted, at least as to negligence.
Let me go back a little bit to your first argument, though. I think you objected to the officer testifying that the slippery pavement was also a contributing cause. Given the admissions, or the new admissions by the defendant, that almost seems to have been helpful to you.
That it wasn't a contributing cause?
That the slippery pavement was a contributing cause.
In the context that he also testified, the officer also testified that the defendant's speed was not a contributing cause, it was not helpful.
Well, the speed, right. I'm just talking
Right.
about the slippery pavement
Right.
part of his testimony.
Yeah, right, Justice. If it wasn't for the follow-up testimony that the defendant's speed was not a contributing cause, then I believe you'd probably be right that maybe the slippery pavement, taken in combination with excessive speed for the prevailing conditions of which the defendant was aware, that may have been helpful.
Because the two parts of the testimony, of the officer's testimony, kind of together, almost, you say, in effect, almost negated the admission, the new admission made by the defendant.
Essentially, yes, Judge, because if he hadn't testified, but for the officer's testimony in this case, there would have been no question of fact as to the defendant's speed. The plaintiff, it was rear-ended. He didn't see the defendant until he was struck. Defendant testifies, I was driving too fast for the conditions, and that's why I couldn't stop in time. Without Officer LaFalse's testimony, that's the end of the inquiry, and we should have been granted judgment under the 4404 motion, judgment notwithstanding the verdict, but during trial, a directed verdict. And I know this will come up. We have been here before on this case on the summary judgment motion. I understand that there were similar arguments raised as to argument number 2, specifically my reliance on the Caristo v. Sanzone case. I would just point out here that we have a new record. That dramatic moment of the defendant admitting for the first time that he was driving too fast for the prevailing conditions didn't exist during the prior appeal, as well as there was some question of some conflicting testimony between the parties about conditions. That didn't exist at trial. The undisputed testimony at this trial was that these whiteout conditions had existed for approximately 5 to 7 hours prior to the collision. The defendant was aware of them the whole time. He knew that there was whiteouts, so there should have been no question as to foreseeability, and more importantly, no question as to whether or not his conduct or the emergency was of his own creation due to his excessive speed. So based upon, first, the inadmissible or the error in admitting the officer's testimony as to the contributing causes, and 2, to ignore the defendant's admission as to speed, which should have eliminated his emergency defense, we would ask that this court reverse the final judgment against the plaintiffs and either order a new trial with proper legal rulings and proper evidence, or judgment notwithstanding the verdict directed towards the plaintiffs based on the defendant's admission.
Thank you, Counsel.
Thank you.
Good morning, Your Honors. Justin Hendricks on behalf of the defendant respondent. I think I'd like to start with, of course, Officer LaFalce. There was a lot of motion practice before trial. There was a lot of discussion during the trial.
How is his opinion as to causation admissible?
His opinion as to causation was not some grand final moment that we built up to throughout the course of his testimony and got him to say, as a matter of, my expert analysis, this is the causing factor. He said there was slippery pavement. He said there was following too closely. He said that there was a possibility.
None of which he observed, of course.
Absolutely not. But when asked such questions as could he have given VTL citations, he admitted he could have cited my client for, and this is in front of the jury. He said, I could have cited the client. By the way, this is awkward saying the things that the officer could have done because it ultimately helps me. But the officer could have cited for following too closely. The officer could have cited for traveling too quickly under the conditions. He made a discretionary decision not to, because he didn't think they would hold up due to the weather conditions he was witnessing with his own eyes at that exact moment.
So let me go back to my question. How is his opinion on causation admissible?
Are we just about the slippery conditions?
How is the opinion of the officer that not the slippery conditions, relative to the defendant's speed?
He would have had no idea how fast my client was going. I mean, how could he have possibly known how fast my client was going? He wasn't there.
Really part of my point.
Well, yes, and my whole point is that the jury heard everything, and the plaintiff wants to
So his
cherry.
opinion didn't matter, is basically what you're saying, that the
He
testimony
gave
is
so
harmless
much different
error.
testimony in different directions. Some helped the plaintiff, some helped the defendant. The jury got to hear all of it, and they decided that there was an emergency doctrine, that a whiteout came that was not foreseeable, and that my client reacted reasonably in response thereto. He says he reduced his speed, had his foot hovering over the brake the moment the whiteout happened. He's,
But Counselor,
trying to do all that he can.
Following up on Justice Paradado's questions, it is error to allow the officer to testify as to causation. And I'm looking at his testimony, he checked that box and said number 66, that's pavement slippery.
Yes.
That's under the category of apparent contributing causes of the accident or something like that. So that causation testimony was inadmissible. Do you agree with that?
It is not inadmissible because he's standing there looking at the pavement.
It's different to say, I observed slippery pavement as opposed to, I believe the slippery pavement was a contributing cause of the accident. Those are two different things, agree?
Those are certainly two different things, Your Honor.
And he expressed an opinion that a contributing cause of the accident was slippery pavement. And that is the alleged error, among others, as I understand it. Do you agree that that was error?
I don't think it was error, because I think that is a conclusion that he's able to come to from a combination of being there, seeing the scene.
But under Huff, our case Huff, and that other one, Silverman or whatever it's called, that the other side relies on, I don't think you would address it in your brief. So that's what I'm wondering, if maybe you're just kind of easing over the error and saying it's really harmless in any event, but you don't even argue that in your brief that I see it, do you?
Well, Your Honor, even if it were error, I certainly agree with you that it would be harmless, because there was ample questions of fact being thrown out by both sides that we charged the jury with listening to and coming out with a final decision.
The difficulty, counsel, with that argument that I'm having is that there was an effort prior to the admission of, and I'm focusing more on the document, the accident report, an effort by plaintiff's counsel to keep that away from the jury, because to allow it in before the jury would be error. In other words, it wasn't a function where we're in the middle of a trial and all of a sudden there's no objection to it and it kind of got in and maybe it shouldn't have got in. There was clearly an objection to it beforehand. There was out of the jury's view, a voir dire examination of the officer concerning it. So the court fully understood that there was a desire by the plaintiff to keep that out and not let the jury take a look at a conclusion portion of that document, number 66, as Justice Kern properly points out, that says the cause of the accident was slippery conditions. And plaintiff's counsel tried to keep that out. So if that effort that the court allowed it in is an error, then it's not a function of just, well, there are mistakes made at both sides and the jury got to hear it all. It's not that simple. If that shouldn't have gone before the jury and, it kind of bootstrapped some of the other evidence, then I think it's a problem.
Well, Your Honor, I think my respectful disagreement with that assessment is that the motion in limine, in particular, was targeting the fact that, admittedly, Officer LaFaus, in his report, unredacted one, blames the whiteout. He was witnessing whiteout conditions as he arrived at the scene, and the jury did not hear the officer mention the word whiteout a single time. That did not come up in front of the jury. And regarding box 60...
But would you agree, though, that the officer also said in the document that was before the jury that contributing to the accident was the slippery condition?
Well, and again, I think that The important distinction is that this is not saying that it was a slippery condition was the proximate cause, the sole proximate cause was only the slippery condition. We did not put an expert reconstructionist on the stand who came to one final explicit conclusion to the exclusion of all others. The slippery pavement was a potential contributing factor. On cross-examination, he had to admit that following too closely was a potential contributing factor, and that going too fast for the prevailing was a contributing factor.
I understand. Thank you, counsel. Anything further?
Only to reiterate Justice Curran's comment that I do not believe that all of these specific objections have been preserved properly, that I would simply ask the court to please look at very carefully preservations of any issues that may be overturned, because there's a lot of moving pieces going on in this one.
We'll do that, counsel. Thank you.
Thank you very much.
Next case up for argument, case 929, Gomez versus Brzezinski.
Hey, good morning, Your Honors.
Okay, let's let your counsel get situated, and let's proceed. Thank you.
Sure. Victor Wright, the defendant appellant Richard Brzezinski. So this is a left-hand turn case over on Route 5.
So you would say, Mr. Wright, if I understand your brief correctly, basically that your client lawfully entered the intersection with the green light.
Correct.
And didn't have time to avoid the accident.
Correct.
And therefore, according to your argument, that's enough to meet your burden to show that you were not negligent as a matter of law.
Correct. The plaintiff never saw our client's vehicle at any time before the accident. My client, it's undisputed that my client is entering the intersection under the speed limit. Posted speed limit is 55 miles an hour. Plaintiff testifies that this is a treacherous intersection. She admitted she knew this at the time of the accident.
You would say this case is controlled by Godwin versus Mancuso, Heltz versus Barrett, and
Number of left-hand turn cases, correct. Plaintiff blindly makes a left-hand turn in front of my client's vehicle. The whole, I guess, question of fact in this case is whether or not, is this issue about the lane. What lane was my client traveling in? And I just like to make the argument that this is simply a red herring. My client testifies he's in the left lane. It turns out that there may have been a vehicle in that left lane.
There are only two northbound lanes, right?
Two northbound, two southbound, correct.
Right, okay.
So there's a vehicle, it looks like there is an uninvolved SUV.
even if it's there, that's all the more reason for the plaintiff not to make the left turn.
Exactly, because she supposedly can't see by it. And then there's a whole other issue about that. If you look at some of the photos, it looks like you can see by it. But that being said, even if my client does go, even if my client changes lanes here, which there's no evidence that he did, but let's assume, play devil's advocate, that he did change lanes from the left lane into the right lane. He's allowed to do that under Vehicle and Traffic Law 1123. And there's no evidence that he did so unsafely. So the reality is that we can't assume that just because just because the plaintiff didn't see my client's vehicle, and just because he may have switched lanes, that just because an accident happened, that he did so, that my client did so unsafely, or that my client was in some way negligent. There's no proof of my client's negligence. Nobody saw my client's vehicle change lanes before this accident. Just because he says, well, he was in the left lane, he may have been in the right lane, that does not create an issue of fact.
The only testimony is to the contrary, that he did not change lanes. Whether he was in the left or right lane, he didn't change lanes.
My client, he submitted an affidavit, he's like, whatever lane I was in, there was no vehicle in front of me. So whether I was in the left lane or the right lane, whatever vehicle I was in, whatever lane I was in, there was no vehicle in front of me. I never changed lanes. I was going into the intersection, and then the non-party witness says that the plaintiff made a left-hand turn in front of him almost very suddenly and immediately. He has, in essence, 2 seconds go by between the moment she turns left, the moment of impact, and he has no time to avoid the collision. Any questions on the bifurcation issue?
No questions, counsel.
Thanks, Your Honor.
Thank you, counsel.
May it please the court, Ethan Collins on behalf of the plaintiff and respondent, Laura Gomez. I'd like to take issue with a bit of the testimony regarding the lane change. The defendant in this case testified that the entire time he was traveling on this road northbound, he was in lane 3, which is the left-hand travel bound lane for that direction. There is undisputed testimony from the plaintiff and the non-party witness that at that intersection, there is a vehicle waiting to turn left, partially obstructing my client's vision, even though she stops, looks carefully, sees that there's no traffic coming, then she makes her left-hand turn. So the defendant testifies the entire time he's approaching the intersection, he's in lane 3. And the non-party witness says there is without a doubt the accident happens in lane 4. That requires him to change lanes at some point between the time he is on that road the entire time.
So just so I understand your argument, counsel, because I'm struggling a little bit, but maybe I'm onto it now. You're saying that defendant's vehicle is in the left lane, and there's a car at the light ready to make a left-hand turn, so it's proceeding in that lane, and that your client on the opposite side making a left, it would be then reasonable for that person to assume that that vehicle is going to stay in the left lane so they can safely make a left-hand turn? Is that where we're at on this?
No, Your Honor, the argument is, and what I believe to be true is that the reasonably careful thing to do for the defendant in this case is to slow down and not pass on the right at a high rate of speed without seeing what's in the other 2 lanes coming in.
We can agree he has the right of way. He's got the light, correct?
Yes.
And entering the intersection, he has the light. And even if he is in the left-hand lane and there's a car making a left-hand turn, there's nothing illegal about moving over to the right lane and proceeding through the intersection, is there?
No, but it needs to be done with safety. And he says he does not know when he sees the cars in the other direction. So he does not know what's there. He says, I don't know or I don't remember. And, therefore he says he can't see what is coming. And regardless of his duty to slow down, he has a duty to see what is there to be seen and to use reasonable care when approaching the intersection.
Your client has that same duty, right?
Correct.
Right.
And I think the Teller v. Enzano case
Is there any proof that your client's vehicle was in the intersection when, as you say, he changed lanes to avoid or to move away from this SUV that was turning left?
I think a fair inference can be made that it took between 2 to 5 seconds, based on my client's testimony, of her making the turn. And given that defendant's rate of speed was approximately 45 to 50 miles an hour, she must have been within that intersection at the time he changed lanes, because he says he's traveling the entire time in lane 3. The accident happens in lane 4. That's a period of time where he must have changed lanes to swerve around the car that was waiting to make a left-hand turn. And I just would like to point out that the Teller v. Enzano case is very similar to this, as cited to in our brief. And that's where a woman is driving, she looks, she doesn't see any traffic, she uses reasonable care, there's no traffic coming in the opposite direction, goes to make a left-hand turn. The motorcycle that strikes her, the court finds in that case that a jury could use a reasonable inference to find that it passed upon the right of a vehicle waiting to make a left-hand turn, which is exactly the same scenario in this case. We have undisputed proof that there was a vehicle waiting to make a left in lane 3, which is one of the left or northbound lanes on Lakeshore Road. And we have undisputed proof that the accident happened in lane 4. Taking defendant's testimony that he was traveling in lane 3 the entire time as he approached the intersection, and that he did not know or could not remember the first time he saw the plaintiff's car, a jury could fairly infer that he changed lanes immediately prior to the intersection, could not see what was in the intersection, could not see what was there to be seen, and took an unreasonable and uncareful risk in entering that intersection in that manner, and was a contributing factor to this accident. And additionally, I would just like to point out that the testimony that he was in lane 3 the entire time, that is his deposition testimony, and he also testified that he did not know or did not remember when he first saw the plaintiff's car. On the day of the summary judgment motion, he signed an affidavit that was different, and he stated exactly where he was when he saw the car. I believe that's a self-serving affidavit. I asked the defendant several times during his deposition, where he was when he first saw the defendant, and he was very non-committal and evasive. I think that is exactly the kind of admission that during trial could be cross-examined. Okay, well, we had you at a deposition. I asked you several times, where were you? You couldn't say where you were when you first saw the plaintiff's car, therefore you didn't have an expectation that they were going to turn in front of you. And now all of a sudden you remember exactly where you were when you first saw the plaintiff's vehicle, and why is that? And I think it would be wise to let a jury hear that and form their own opinions as to what caused this accident.
Any further, counsel?
Just as to the bifurcation issue, I think one of the arguments was that it was not preserved, that I didn't argue anything other than the plaintiff's injuries have a bearing on the happening of the accident. I think during oral argument, I had made the argument that it is not a complicated case. It's simply 3 witnesses, what happened, and then there's a causation issue on the back injury. So I made the argument that this does not require 2 separate trials. It doesn't assist in the administration of justice. It doesn't make it quicker or easier, and so I would just say that that point was preserved, and it still is my position.
Thank you, counsel.
Thank you.
Case 930, Carpentieri versus Clark.
Good morning, Your Honors.
Counsel, if you wait just a minute for your opponent to get situated. Thank you. Proceed.
I will assume that you'll want me to waive any kind of factual dissertation, but I believe there are just 2 issues that the court has to look at. One, whether the trial court erred in finding that Paul Clark's conduct was the sole proximate cause of the accident. I don't think we're not disputing that he was negligent, God rest his soul. What we are disputing is that Mr. Carpentieri's actions were also a proximate cause of this accident. And the second is whether the emergency doctrine applies. The lower court never addressed that, but we've addressed it in our brief. It's undisputed that Mr. Carpentieri was speeding and highly intoxicated at the time of the accident.
I'm not sure it's undisputed that he was speeding. As to the other, I think you're right. Tests showed that he was impaired.
Yes.
Okay. And I believe that the record shows that at some point, a witness said that he was going too fast, maybe, fooling around with another driver. But at that point, I think we don't really know, but we know what you allege.
Well, Dr. Tasbar, who gave the statement to the Lancaster police, indicate that Mr. Carpentieri was in the curb lane, swung out into the passing lane. This is a 4-lane with a median 45 mile an hour, and indicated that he was going at a high rate of speed or
At some time before the accident.
This was before the accident. Excuse me. Tim Onions, who is the accident reconstructionist that we put forth, indicated that his top rate of speed based on his accident reconstruction was 57.8 miles an hour.
What did he base that pre-impact speed on?
On the skid marks, on the length of the skid marks, taking into account that there had to have been a delayed reaction time because of the intoxication. So
Instead of a 0.75, it would be 1.0. It would be delayed by a quarter of a second, right?
I think it was more than that. I thought it was 1.5. That the delay was roughly twice of what a sober driver would have had, the reaction.
I am just a little concerned about the expert report of Mr. Onions, in that I'm not sure where he got a lot of his information, not only except for the measurements, but he also didn't appear to address the information provided by plaintiff and plaintiff's expert.
Well, these reports came out simultaneously. So they came out at the time of the motion being made and our response. I can't talk today.
Well, for example, Mr. O'Connor, I think, some of the information plaintiff relied on had to do with the, black box of your client's own vehicle. So I would imagine that information would have been available to him as well to make some comment about how long defendant's car was in the roadway before it got hit, et cetera.
Yes, but I believe that Mr. Onions rebutted that with the stopping distance. and extrapolated backwards with the delayed reaction time as to when he should have noticed something and why it was
Mr. O'Connor, let
delayed.
me ask you about Tim Onion's report. Was there an indication in his report, did he rely upon, I think they refer to him as yaw marks, which is, as I understand it, please correct me if I'm wrong, when the operator engages the brakes?
Yes, that's when the skid marks began, or
Right.
roughly.
And
thereabouts.
so he did a measurement from that point, knowing when the driver engaged the brakes. Right, so we know when that point happened.
Yes.
And when the collision occurred. There was a
Yes.
distance. And so was part of his opinion, and this is where I need your help, was part of his opinion that had he been going at or near the speed limit, he would not have reached the collision point?
Yes. You would have.
Is that just a mathematical formula?
Pretty much, Your Honor. Had he not been speeding, first of all, and had a normal reaction time, the braking would have occurred earlier, allowing his car to either a lesser accident.
Forgetting
or
about that,
stop.
the reaction time, we know when the braking occurred.
Mhm.
And his opinion is the distance between when the braking occurred, forget about reaction time happening before then. We know when the braking occurred. The distance between when the braking occurred and when the collision occurred, had he been traveling at or near the speed limit, the collision wouldn't have happened.
That's correct.
Well, that's math. That's based upon one point versus another point and a distance, right?
Yes.
Okay.
Bill
Was your
Reynolds couldn't have
vehicle-
said it better.
Was your vehicle, or was your client's vehicle stopped at the time?
It was
of the
stopped.
collision?
So your client's vehicle entered the roadway and stopped right in front of plaintiff's vehicle?
It stopped, and we can only surmise, or guess.
That the roadway wasn't clear for him to continue?
Yes, but the interesting thing was, when Dr. Tasbar testified, he put two vehicles on Transit Road, or when he made a statement to the Lancaster Police, he put two vehicles with Mr. Carpentier's vehicle being behind the other vehicle. That vehicle was never involved in the accident, never stopped. So there had to have been an area where that vehicle wasn't blocked. So, for Mr. Carpentier to say, I had no other possible action other than to strike the clock vehicle, I think is disingenuous, especially in light of his testimony, which was pretty dicey to begin with. I think there were a lot of credibility questions about his testimony. Now, just briefly on the emergency doctrine, I believe it all ties in together. If this was an emergency that was contributed to by Mr. Carpentier's conduct, they're not entitled to a dismissal of any defenses that we have based on the emergency doctrine.
Thank you, counsel.
Thank you.
Charles Desmond for Mr. Carpentier. As your honors can see, there's no winners in this case. Mr. Clark's dead. My client is severely injured. Mrs. Clark is severely injured. There's also no dispute that Mr. Carpentier has got a troubled past. He was a military veteran, been treating for years for issues relating to that. But that's not what this case is about. This case is about 2 seconds. Mr. Onions doesn't address. It's about 2 seconds. We know when Mr. Clark pulled into the road, there were 2 seconds between when he pulled into the road, unanticipated, and the collision.
And tell us how we know that.
Well, we have the black box.
Okay.
That's what everybody has.
Defendant's car's black box.
The black box.
Was
We
that
have that.
accessible to Mr. Onions?
Mr. Onions had that information.
But it's not referenced in his report.
Right, because he couldn't refute it. It didn't help him. Because we know there's 2 seconds. When you take out the perception reaction time, he says 1.5, we say 1.6. That means we have half a second or 4/10 of a second. It's impossible for my client to stop at any speed, much less the speed limit, 35, 30, 25. You can't do it. That's why Onions doesn't even talk about it.
Mr. Desmond, address the question I raised with your opponent, though. I'm troubled by the simple math argument here, and that is, you're talking about reaction time. He didn't have time to react. but we know when he reacted. We know when he hit the brakes.
Right.
There's a point in the road, the mark's made, that says he's hitting his brakes right here. That's the reaction spot. We also know when the collision occurred.
True.
And doesn't math tell us, if we know what the speed limit is, whether or not he would have, his vehicle would have stopped before the collision? And that's what Onions is saying.
Yeah, but Puckett says to the contrary.
But these are issues for a jury, aren't they?
No, because Puckett has no basis for his opinion. We know, using the black box, we can move back from where the car was stopped, clock, to when he entered the road. We know that. Onions knows it, Puckett knows it, everybody knows. The Lancaster police knew it. They arrived at the same conclusion as Puckett. There was not enough time.
What was the distance from the beginning of the yaw marks to the,
77 feet. So in actuality, they say that Mr. Carpentier, wasn't paying attention, didn't see it. He probably reacted before the car was actually in the road. And that's something you can't expect drivers to do. If you expect every driver to go down Transit Road, when a car comes, getting ready for traffic to clear, if I'm going 45, I say, oh, he might come out, so I better slow down to 20. Well, we're going to be up here every other week on rear-end accidents, if that's standard. Standard was he was going down, he saw the SUV, and it appears he probably anticipated something was going to happen because he slowed down before it got into the road, but he still didn't have enough time with perception, reaction, and the time that was there. And he obviously, that's the key thing in the case. Onions doesn't even look at it for obvious reasons because it would sink his argument. But that's all I have.
Thank you, Counsel.